Welcome back. This is part 5. So how do you feel about part 3, chapter 2, section 2 of the CISG? Are you recovering from a bit of a shock, or are you still feeling quite comfortable? Scrutinizing these provisions, did the CISG rules sound familiar to you, or did you find them rather unusual against the background of the Swiss Code of Obligations? Well, let's see. Article 35, paragraph 1 establishes the principle that the seller must deliver goods which are of the quantity, quality, and description required by the contract, and which are contained or packaged in the manner required by the contract. Paragraph 2 adds a number of elements of a definition for what we have to understand by conformity of the goods. All of this is in line with what is, in essence, also contained in Article 197 of the Swiss Code of Obligations. Paragraph 3 of the same article in the CISG states that the seller is not liable for any lack of conformity of the goods if at the time of the conclusion of the contract the buyer knew or could not have been unaware of such lack of conformity, which corresponds to what the Swiss Code of Obligations states in Article 200. According to Article 36 of the CISG, the seller is liable for any lack of conformity which exists at the time when the risk passes to the buyer, even though the lack of conformity becomes apparent only after that time, which includes defects that come to light subsequently, and which is pretty similar to what follows from Article 201, paragraph 3 of the Swiss Code of Obligations. Articles 38 and 39 refer to the duty of the buyer to examine the goods and to notify defects to the seller. Article 39 makes it clear that the buyer loses the right to rely on a lack of conformity of the goods if he does not give notice to the seller specifying the nature of the lack of conformity within a reasonable time after he has discovered it or ought to have discovered it. Again, all of this is very similar to what we find in the Swiss Code of Obligations in Article 201. However, there is one subtle but important difference that is worth mentioning. While under the CISG, the buyer must notify the seller within a reasonable time after discovery of a defect, the Swiss Code of Obligation is stricter. It requires the buyer to give notice of any defects discovered without delay or immediately, which again reflects the tendency of the Swiss Code to protect primarily the interests of the seller. So most of the basic rules that the CISG contains with regard to the conformity of the goods are quite similar to what we are familiar with from the Swiss Code of Obligations, except that the CISG is less strict in its wording concerning the time frame for the notice the buyer has to give to the seller in case of a lack of conformity of the goods sold. Let me now turn to the consequences of a lack of conformity of the goods delivered by the seller, or more generally speaking, of a breach of contract by the seller. This brings us to Part 3, Chapter 2, Section 3, and Chapter 5, Section 2 of the CISG. In the event of a breach of contract by the seller, the buyer is entitled, according to Article 45, to a number of claims. On the one hand, he can claim remedies that are specified in Articles 46 to 52. On the other hand, he can claim damages as regulated in Articles 74 to 77. In what follows, I would like to focus on those remedies, on those specific rights provided in Articles 46 to 52. In that context, an important article from Chapter 1, General Provisions of Part 3 of the CISG, is to be taken into account as well. This is Article 25 that offers a definition for what the CISG calls a fundamental breach of contract. This notion plays an important role within the system of remedies because some of those remedies are restricted to cases of a fundamental breach of contract. And here at the bottom of the slide, you have the text. According to Article 25, a breach of contract committed by one of the parties is fundamental if it results in such detriment to the other party as substantially to deprive him of what he is entitled to expect under the contract. At this point, I would like to invite you to analyze the system of remedies specified in Articles 46 to 52 in connection with Article 25, and to compare that system to the remedies provided in Articles 205 and 206 of the Swiss Code of Obligations. Try to find out what is similar and what exactly is different. This will also allow you to make up your mind about the advantages and disadvantages of the CISG and the Swiss Code of Obligations. What is better? When doing this comparative analysis, it is helpful to keep in mind the example of our case. This kind of analysis is highly relevant in practice for contract drafting. It is the basis for evaluating the consequences of either having the contract governed by the CISG or adding a clause that excludes the application of the CISG.